Good afternoon, everyone, and welcome to today's webinar. My name is Varali, a Senior Associate from the IP department, and I'm joined by Kun Kasama, our IP partner with expertise in IP commercialization. Today, we are delighted to be here to discuss practical IP due diligence for entrepreneurs, a timely and important topic in today's collaborative business world. Before we begin, I would like to address a few housekeeping notes to help the session run smoothly. First, this webinar is being recorded. Second, all participants are currently on mute to minimize background noise. Third, we encourage you to ask questions. Please send them through the Q&A box or use the chat function located at the bottom of your screen. Fourth, all questions will be addressed at the end of session. But if we run out of time, we follow up via email indeed. Lastly, your feedback is truly important to us. At the end of this webinar, you will see a QR code appear on screen. So please take a moment to scan it and share your thoughts. Now let me walk you through what we will cover today. We will start with part 1, why IP due diligence matters, setting the stage for why this process is important in any transaction. Then in part 2, anatomy of an IP due diligence exercise. We will explain the process and highlight the key details we focus on. In part 3, price driver, we look at what factors move deal value up or down. In part 4, we will discuss common pitfalls and proactive solutions by industries. And finally, we wrapped up with closing takeaway, bringing together the key action you can take from today's session. With that, let's get started. I now hand it over to Kun Kasama to begin the presentation with the most important question: why IP due diligence matter?
Thank you, Varari, for the introduction, and good afternoon, everyone. So in our view, IP due diligence is really about governance, risk mitigation, and value creation. Whether you are going to launch a new product, entering into a partnership, or raising a capital, or preparing an audit, the same questions would come into mind. Do you own what do you really think you own? Is the IP properly protected and free to use? Are there any encumbrances that may limit how you may commercialize your IP? Answering these questions early reduces operational and legal risks and strengthens your negotiating leverage. It also helps R&D and commercial strategy by focusing protection on high-value assets, retiring obsolete IP, and cleaning up gaps in the chain of titles, employment or contractor agreements, and so on and so forth. So when we talk about IP due diligence, we are really talking about a set of core checks that will help us make smart, informed decisions. Facts are what matters most here. IP due diligence helps us identify and mitigate risk. We can spot potential infringement, transfer restrictions, and any other problems early on, giving us a chance to fix them or put protection in place. IP due diligence also helps us value things more accurately. When we really understand how strong the IP is, where the weaknesses are, and if it can actually be enforced, we can make sure that the price is right. When it comes to structuring a deal, IP due diligence lets us customize things like warranties, warranties, and set up escrows or carves out or license and other terms that may be needed in an agreement. And after the transaction, good IP due diligence will help everything integrate smoothly. We can maintain continuity of use, keep up of renewals, follow the roadmap, and ensure compliance. Getting the time right also saves time and money. An early quick check on core ownership and non-assignable third-party licenses can surface issues to remediate, reprice, or restructure before costs escalate. Ultimately, good IP due diligence is not just about a deal exercise, but it should be considered as an ongoing habit that keeps your option open, protects your competitive advantage, and enable growth. Many types of deals need IP due diligence, whether it's a selling of an IP asset, selling of a whole company, merger, acquisition, and any types of rights transfer. Even if you are just doing equity investments, you need to understand and consider how IP risk may affect your investment. Asset purchase absolutely need IP due diligence because you are buying specific rights. And if you're getting a loan secured by an IP, the lender will want to know they can take those rights if the loan isn't repaid. Joint ventures, technology transfer, franchising, licensing also require careful review to confirm that the rights are strong enough, can be transferred when needed, and do not conflict with other agreements. Clear roles lead to faster, more reliable review, which boosts efficiency and accuracy. From what we have seen, the best way to divide up roles should be that the buyers are to check the facts, set the price, and protect their interest through contract provisions. The sellers get all the records organized, explain the story of the IP rights, and proactively fix issues. The technical and finance team confirms technical details and figures figure out the financial impacts. And the lawyer's roles, we would identify and catalog all IP assets, verify who owns what assets, how valid and enforceable the IP is, analyze infringement risk and potential lawsuits, evaluate IP protection strategies, and see if they are sufficient, advise on the deal structure and its risk, and finally, we would prepare the due diligence report that sums up all the findings, highlights the key risk, and provides recommendation.
Let's move to practical part, how to run an IP due diligence. My goal here is to give you a simple, usable structure you can apply no matter the deal size. Good diligence starts with clear boundaries. Think of scope as drawing the box around your work IP asset. What's in, what's out, and how deep to go. 3 choices matter most. First, the look back period. Always start from the very beginning, sometimes even before the company was incorporated. Second, focus. Prioritize assets that genuinely drive value, like the main code, key patents, flagship brands, or core dataset. List them explicitly in your scope so everyone in the deal knows where to focus. Third, materiality. Define what really counts as significant. For example, if you forget a small photo license in marketing post, this is not critical. But if your main trademark is not owned by the company, that's a real major issue, right? Define this early, keep the review focus, and minimize surprise later. Once you draw the box, everything else like timing, effort, and reporting falls into place. We turn scope into a simple step plan. Story first, proof second. Step 1 is about understanding the story behind the company's IP. We start with short questionnaire, the 5 straightforward questions that help us see how the right word create, use, and manage. First, we ask what was built, the main product, technologies, or creative works. This helps us identify which asset genuinely drive value and needs closer review. Next, we ask who built them, like employee, contractor, or external partners, and when. This will let us trace creation to ownership and confirm that proper assignment agreements are in place. Then third, we look at what outside material we use, like open source software, licensed artwork, music, or font, and then check their license term. This step help uncover inbound rights or obligation that might affect future transfer. Then we also ask which contracts apply, employment and contractors agreement, NDA or joint development projects, vendor terms or customer license. Each one can affect who own the rights, how can they be used, whether they can be transferred in a sale later. And finally, we ask how the company has the right to use and transfer everything, the key legal basis for ownership or license use. Step 1 is quick, factual, and tell us where to look. Then step 2 is about proof, the evidence that supports the story with fact. We will collect the document that demonstrate ownership, validity, and control. These typical include a list of IP assets, registration and renewal records, employee and contractors agreement, license and assignment agreements, authorization letters, and any dispute-related information. If seller doesn't provide this, usually the buyer's lawyer step in to gather them. Then we test what we gather. First, title and ownership. We have to confirm that everyone who touched a core asset signed an assignment with the present tense language like hereby assigned, not will assign. So right transfer automatically. Second, registration and maintenance. We verify that all IP are real, current, and cover key product and markets. We link each product or brand to the IP registration that protected. Third, validity and enforceability. We assess how strong each right is. Patent claims should match core feature. Trademark should be distinctive, cover relevant goods and service, and used consistently. Copyright should be original and rightfully owned with complete chain of title. Fourth, exploitation and monetization. Here we look at how the IP makes money to see if licenses are transferable, if there are territorial limits, consent requirement, or any clause that could restrict future sales. Fifth, infringement and dispute. Here we are not litigating, we just assessing risk exposure. We list any demand letters, lawsuit, or takedown, showing what claim, the current status, potential costs, and impact on operation. Anything serious gets flagged for early action. Finally, data and privacy. Data only has its value if we have the right to collect, use, and transfer it, right? We trace where data comes from, what user agree to, and whether the right extend to new use like AI model training. After reviewing the evidence pack, we turn finding into clear, useful report. First one is the red flag summary. This will highlight only the key issue that could affect price, timing, or deal structure with short notes on fix. Next is the full report, which include additional details like a list of assets, license map, dispute table, and action plan with owners and deadline. Finally, the executive summary that connects each main finding to a practical solution. With clear scope, process, due diligence becomes more than a checklist. It tells a simple story that links facts to value and builds confidence to both seller and buyer side. Now let's discuss what can move the deal price up or down.
In this section, we'll explore the key factors known as price drivers that can significantly influence the value of a deal when IP is involved. Understanding these drivers is essential for both buyers and sellers as they directly impact negotiation, risk allocation, and ultimately the final purchase price. Price drivers can be both negative and positive. What appears on the slides here are what are typically move the price down. Issues like ownership gaps, such as incomplete chain of titles, or missing assignment documents, or non-transferable licenses in the core assets can lead to price cuts or money being held back until problems are solved. If you have used a software under the copyleft license, it means that you were allowed to freely use, modify, and distribute such software, but with the key condition that any derivative work must also be distributed and shared under the same license. This would have created restrictions that can also push price down. Weak protection in key countries, such as lapsed trademarks or thin patent coverage. Life disputes with a real chance of an injunction or high damages, or any restrictions on data use or transfer, these can all lower price. This risk may lead not only to price reduction, pullbacks, but also jeopardize the deal if not properly addressed. On the positive side, well-documented and protected IP, clean ownership records, transferable contracts, and clear data rights can all enhance the value of a business. These strengths can justify a higher price or more favorable deal terms. By understanding and leveraging the price drivers, both buyers and sellers can implement practical strategies that are beneficial to them. Our suggested strategies for buyers are for you to turn findings into fair terms by translating each risk into money and time. Estimate the cost to fix the issue, the cost to the chance of a bad outcome, and the revenue at risk. Then use these estimates to choose the tool that fits. Your tools could be a holdback of a funds for a certain time period to cover something that you believe can be fixed. Or you may use special indemnity clauses to cover a narrower risk that can be defined. Or use a closing condition to address any remaining unresolved issues when you have time constraints for the deal closing. You may seek price reductions or contingent payments to reflect the cost or risk of a problematic IP issues. Whenever the seller proposes a fix, the buyer could set clear milestones and link fund releases to the proof of delivery. If a finding is positive, such as strong IP rights or licenses already cleared for new markets, seller may negotiate for better deal terms. Then buyers may negotiate to include reduction of escrow, speeding up release of funds, or make a deal that includes an earn-out provisions where seller receives additional payments if their IP generates a certain amount of income after the sale.
On the seller side, the aim is to protect and maximize deal value by being prepared. Fix a small issue early, keep IP record organized, and show that everything is in order or at least fixable or manageable. When buyers see clear evidence and practical solution, they gain confidence and the price holds steady. Begin this by closing any gaps. Make sure that all the chain of title are complete, assignment as agreement are signed, renewals are up to date, and any ownership issue are resolved. Keep records that clearly link key product to their rights and review contract to confirm they are current and can be assigned. Address data and third-party issue ahead of time and record how they have been handled. Then highlight your strength like strong protection, consistent use of trademark, and clean documentation. If something is still pending, usually the seller will offer a simple plan like short-term indemnity or define follow-up steps to keep the deal running smoothly and preserve the deal value. Now we are going to move to theory to real story. In this section, we will highlight the most common IP issue and share practical ways to avoid or fix them. Given that we have time limits today, so we will focus on the critical points. And we are going to start with the entertainment industry. In entertainment and media deals, ownership issue often cause problem. Even one missing signature or unclear agreement can lead to delay, content takes down, or lower deal value. The most common problem is a broken chain of title. Maybe a composer or songwriter never signed any agreement. This can delay deals or cause problem to deals. The fix is quite simple. So we need to create a timeline for each work and make sure that every contributor has signed agreement. Confirm who owned the master, who owned the composition, and make sure that the paperwork signed match. In game and animation, third-party tools and artwork can cause issues sometimes because contractor may use plug-in or art pack that is not licensed for resale or subsequent version, like the part 1, part 2, part 3, right? So deals may be put on hold until every asset license is checked and clear. To avoid this, list all third-party elements and make sure you have the right to reuse and transfer them. Finally, media. Media often get overlooked. Like having online, right? It doesn't always mean that you can use the content for streaming apps or new format like the VR. So we need to always confirm your rights match your distribution plan now and for the future format as well. One common problem in music deals that I personally have encountered is unclear wording in composer agreement. Some of these contracts are titled as sale and purchase agreement, but then in the agreement, there's provision that include clause stating that buyer must pay for the production of each new master. So court have interpreted such language as a license rather than an assignment. This creates like serious complication for the buyer and also can trigger indemnity clause. Another recurring issue involves the language used in copyright assignment agreement for any kind of verb. In this case, it's musical verb. Under Thai law, a copyright assignment must specify the duration of the transfer. Otherwise, the copyright automatically revert to the original owner after 10 years. And from my experience, many agreements omit this assignment period, causing ownership to revert to original owner, and this leads to significant problem for buyer as well. In the consumer goods sector, IP issue often emerge as brands grow beyond their home market. Trademark ownership, for example, they can become tangled when company names differ in different countries. For example, a business may register their trademark under a holding company in their home country, but then choose a different entity for overseas filing to gain tax advantage. So it is essential to confirm that proper owner in each jurisdiction and maintain clear, consistent proof of the ownership. Trade dress and design protection can also weaken when filing are delayed. This often happens when business tests product in the market before securing protection, and the product later becomes successful. A third party may then file the mark first, like the trademark squatter, and leading to dispute and possible cancellation proceedings. Early filing is therefore the key to keeping rights strong even during the testing phase.
In manufacturing, intellectual property pitfalls are both common and costly. One of the biggest risks is unclear ownership of tooling designs or technical files. Supplier contracts often fail to specify who owns critical assets like molds, CAD file, firmware, or even improvements made by manufacturer. Without clear terms, factory may reuse your designs, sell overrun products, or supply look-alike goods to competitors. If you have visited our firm, Diligence, you will know that we have a museum of counterfeit goods here. You will see examples of real cases where factories sell expired licensed products or supply look-alike goods to competitors. One notable example of a known case is a footwear company who initially manufactured its shoes in various overseas factories. However, the company found that some of its manufacturers started producing unauthorized look-alike shoes using the same molds and designs that the company had supplied. This happened because the company's earlier agreements did not clearly specify ownership of the molds, designs, and improvements. So some factories felt entitled to use the tooling to make or sell similar products under different brand names. These copycat products flooded the market, especially in the regions where companies had not yet secured patent or design protection. As a result, companies suffered loss of sales and had to engage in lengthy and expensive litigation in multiple countries to enforce its rights. The company eventually strengthened its manufacturing contracts to explicitly assign ownership of tooling, designs, and improvements to their company, expanded its IP filings internationally, and implemented stricter controls over its supply chain to prevent factories from leaking or misuse their know-how. This real case example underscores the importance of IP protection and strategy. Ideally, the contracts should include a clause that clearly assigns ownership of molds and designs to the company and prohibits reuse. But if this issue has been discovered late in the game, a confirmatory agreement may be a way out. For software business, software teams move fast and don't always keep up the paperwork in sync. The biggest headaches tend to be the missing assignment agreements from early developers, undocumented code origins, and open source use that could force you to share your own source, such as in the case of copyleft license that I earlier mentioned. Third-party tools and cloud services can have terms that block assignments in a deal or limit what you can do if you change pricing or features. Customer contracts sometimes give away rights that make future licensing harder, like perpetual source code access or unlimited users. Data is another thing to watch out. Analytics and training data might live with the vendors, or contracts might not let a buyer keep using it. To lower the risk, we need to make sure every developers, contractors, and contributors have signed present tense IP agreement and confidentiality terms that are enforceable under the laws in the relevant countries. It is important to keep records of all components, including libraries, dependencies, and modules that make up of a software application, and review the open source licenses. Resolve any copyleft exposure by swapping content components or changing how you link them to your software. Inventory all third-party software and service agreements, flag the restrictions, and confirm you can transfer and keep using them after the deal. Review your largest customer contracts for rights that could constrain your model and plan carve-outs or amendments.
In invention and design, timing and ownership are critical to preserving value. One of the most mistakes is disclosing new idea too early, whether during product demos, at trade show, in investor pitch, or even in online posts. Such disclosure can instantly destroy patent or design rights, as protection generally require filing before any public release. This is why it is important to always track when and where ideas are shared and to proceed with filing to secure your rights before any public disclosure. Ownership issues are another frequent trap. Work created by freelancer contractor may not automatically belong to company. So without clear contract transferring ownership, creators may retain or challenge the rights. To avoid this, use present tense wording like I hereby assign in agreement and make sure that every contributor signs the agreement before work begins. This simple step ensures full control and avoid dispute later in the deal process. And last, on pitfalls across industries. I have to mention that not every business sector rely heavily on IP. For some industry like entertainment and media, they are IP heavy. But for some industry like consumer goods, they are less IP heavy. But whether IP forms the core of business or simply support it, similar issue often slow down the deals and quietly reduce value across sector. A common starting point is the employment contract. This is the point we can look at immediately in your employment contract. Under Thai law, employees own the copyright in their creation unless the agreement says otherwise. So by default, without any agreement, ownership rests in employee. Therefore, if we don't have a proper agreement, ownership can later be disputed or challenged. In this regard, if we include straightforward IP provision or short assignment letter from the outset, this can prevent problems before they surface. Next is record keeping. This is another frequent pain point. Inconsistent filing, missed renewal, or missing proof of use may appear minor, but they can delay the ownership transfer or weaken IP protection. So it is important to keep consistent names and maintaining a single organized list of IP, like IP portfolio or IP catalog, to help ensure that the IP portfolio remains clear, current, and transaction ready. Last, on trade secret. Trade secret also need attention. Define what information is confidential and then limit access to those who truly need it, whether limit access by physical access or the software, and keep short record showing who has that access. This simple step make it easier to prove control later and help protect valuable know-how during and after the deal. This is because trade secret, it will be protected as long as the measure for keeping confidentiality remains, right? And here comes the last part.
Before we take questions, we would like to conclude that intellectual property due diligence pays for itself when it replaces uncertainty with simple, dated documents and turns findings into price, protections, and a clear plan. We recommend setting scope based on where value and risk concentrate. We treat data room preparation like a product release. We advise keeping reports short and useful with clear links to the contract terms. Quantifying fixes and connecting them to milestones has proven effective. With this approach, due diligence becomes a tool that helps both buyer and seller closing the deals stronger. Lastly, we wish to emphasize that our talk today comes from our professional experience and is for general information only. They are not legal advice. You still need to talk to legal professionals for advice tailored to your specific situation. We appreciate you joining us today. If there is any question, please feel free to type in the chat box or Q&A box. We also welcome any comments or sharing of your personal experience in IP due diligence for the benefits of other audience. If anyone wants to share anything.
I think I see I see the question in the chat box.
Okay, so I see one question. They said how to address open source. So actually, I discussed this earlier in my slides regarding software. So it's very important to keep records of all components that make up of a software application, including the open source licenses. You may have to go back to the license open source licenses and review them. And if you find that you are into the copyright license that I earlier discussed, so that's could be something that you have to consider whether you can change the components or change how you link them to your software. If that cannot be fixed, then we need to flag that. And it's going to be one of the concerns regarding the price up or price down that we earlier discussed. You may need to renegotiate the price or the terms, and maybe you add some covenants on indemnity clause or escrow accounts, depending on whether you are a buyer or seller. So all these can be the tools that anyone can use in the due diligence process. I see another question. It says, could you describe the most challenging intellectual property due diligence matter you have handled to date and explain how you resolved it? Warali wants to go first?
Of course. From my experience, one of the most challenging IP due diligence case I've handled so far is related to a music deal involving close to 100 songs. Each song had different rights holder, like songwriter, performers, producer, and labels, and each came with its own supporting agreement. Some were assignment contracts, others were licensing or publishing agreement, and a few were just email confirmation, short statement or something. So at the time, we had to carefully map all these documents to each song to confirm the chain of title, who actually owned what, and whether the right could be transferred. That took a lot of time because many agreements were ambiguous, incomplete, or missing key clause. In some cases, the seller did not even have copies of agreement or any proof at all. So we have to trace the right through public records and sometimes interviews. It was a long and detailed process, but that's part of our job, right? The lawyer job. So with structured workflow, a clear checklist, and a strong team of 10, 15 people, even complex catalog review like this can be handled efficiently. So the challenge part is the documentation, in fact. And what about you? Can you share your experience as well?
Yeah, for me, I would say what I found most challenging is the tight time frame, because many times IP due diligence is part of the bigger deal like M&A or acquisitions, and it usually comes to our IP team like very last minute in the deal cycle. We have very short time frame to check everything, even though it seems that Wanali mentioned many steps that actually we had to take, but in the real life we do not have that much time. So that tight time frame combined with incomplete or fragmented information makes it very challenging. But with that, if I had to if I have to resolve that, I would say that when timelines tight, I would conduct a risk-focused due diligence process. So it means I only focus on the real risk issues. I would provide a quick red flag, high-level advice to clients, and probably will go deeper only on the red flags issues that happens to be with the core IP assets that is in the deal.
You made a really good point because during the presentation, I mentioned that there's three types of report, right? We have red flag report, we have full report, and we also have the executive summary. We have three types, but it also depends on the client, on the case by case basis as well. Because some client they don't want to see the full report; they just want to see what's the problem and the fix, right? And in your experience, I understand that you don't have to prepare all the three as well, right? Just
Yes.
only for IP heavy industry like entertainment or music.
Yes, that's right. And most of the clients I found that they don't like lengthy reports either. They want executive summary, short and concise, and only hit the points. So
Right.
yeah, I think for most of our clients would prefer the risk-focused report.
Totally agree.
Yeah, so right now I don't see any other questions on the chat box. Thank you very much for your kind attention, and we hope we have opportunities to speak to you again in the near future.